Signed on January 5th of 2024, Veterans Guardian loses a federal case, and this absolutely matters for anyone in the claims consulting business. I believe this sets a precedence and is a very, very good indicator that VA Claims Insider and other companies that are on the hook and not on the hook yet need to pay attention. Veterans, if you live in New Jersey and soon to be Virginia, you do not have to pay a dime to these companies, even if you already signed the contract. Quick background: New Jersey passed a state law prohibiting anyone from collecting fees for or assisting a veteran's VA claim. If you want information on that, I'll leave a pinned comment below where I review an email sent by Veterans Guardian to another veteran informing them that they will have to pay once Veterans Guardian wins the appeal. Well, fast forward to today, the appeal was sent and the appeal was denied. That's what we are about to look at. This is an absolute game changer and a win for the VFW as they really pioneered that piece of legislation through the gauntlet. And depending on how you see claims consulting companies, that's either a win or a really big loss. Let me know in the comments. So here we have Veterans Guardian going after the Attorney General of New Jersey, which is a very ballsy move in my non-legal opinion. Okay, there's a lot of background information. I'm just going to cover the highlights, and I'll leave this comment in the pin section as well. But in this action, New Jersey Senate Bill 3292, that's the one that prevents, right, which prevents a business like Veterans Guardian, among other things, charging veterans for assistance with disability claims unless the business is accredited by the United States Veterans Administration. Plaintiffs asked the court to declare that 3292 violates their First Amendment rights and to enjoin defendant from enforcing the law. So Veterans Guardian's argument is they are going against our First Amendment rights, which is free speech. And there's a few clauses in that this motion really digs into. You can read the background on Veterans Guardian, what kind of company they are, and then the background on the defendant, which is the Attorney General. Looking at some statutory framework here, let me turn this to yellow. As relevant here, and I want everyone to pay attention to this, federal law prohibits unaccredited individuals from assisting a claimant with an application for VA benefits. It is illegal, which is funny to me that Veterans Guardian is challenging, their practice is illegal, and it's just, you can't make this stuff up. You really can't at all. While the VA does not currently have the authority to enforce these requirements under federal law, so it's still law, the VA just can't do anything about it. There are bills pending, including the Guard VA Benefits Act. Now, I do find this weird that this is included in here because we've seen no movement on the Guard Act, at least not that I'm aware of. If that has changed, I would absolutely love to know that. And if so, let me know. Scrolling down here, this is a overview of the New Jersey Senate Bill, the 3292. Prohibits any person from receiving compensation for advising or assisting in any individual with regard to any veterans benefits matter except as permitted under federal law. There you go. It's pretty straightforward. We're going to scroll down. This is a bunch of legal mumbo jumbo. If you really want to read it, some of it is pretty funny, but we'll scroll down and just cover the highlights here. And so here, the court agrees. Look at this. The court agrees with the Attorney General that this case is most analogous, to this case right here, and basically that this case or the bill regulates conduct and not speech. So that's if I was a Barney style, I'm a Marine. I like things simple. The court is basically saying, hey, this argument's not going to work. Looking at this case, we're looking at regulating the conduct of an illegal practice according to federal law, and this bill is not really about speech. And so from the get-go, it really looks like the court is siding with the Attorney General, and obviously that's what's going to end up coming out of this. But let's scroll down here. The Attorney General contends that this expansion fueled. Now, this is a very, very interesting part. Fueled an influx of predatory practices targeting veterans, and in 2022 alone, the Federal Trade Commission reported that benefits consultants and other businesses have defrauded veterans of over $414 million. $414 million. Okay. Something to remember is looking at 22 alone and the predatory practices, we really saw the influx during when? The PACT Act, meaning presumptive conditions. So imagine how much money of this 414 million is simply from presumptive conditions. It does not get more predatory than that. It's you are stealing money from the veteran at that point because no assistance is needed on a presumptive condition at all. As such, the court finds that the law on its face satisfies the O'Brien test. You can go back up and read that, and survives immediate scrutiny, even assuming that this bill regulates protected speech. Plaintiffs have not shown a likelihood of success or raised serious questions going to the merits of their First Amendment claim. Plaintiff's motion for a prelim injunction on this basis is denied. Let me get the red out for that one. Is denied, okay? The court's basically saying, hey, not good enough. Got to do better than that, right? Got to be quicker than that. Okay. And by contrast, this bill does not bar Rudiment or Soto, and so that is, it says Veterans Guardian, but these are the plaintiffs, the persons of the plaintiff. So this bill, the New Jersey bill, doesn't prevent these people from filing VA claims or seeking assistance from Veterans Guardian, okay? It prevents Veterans Guardian from generating a fee on that assistance. So, hey, Veterans Guardian or VA Claims Insider, or you name your company, if you want to help veterans so much, you can do that, okay? You can absolutely do that. You just can't charge 5 times the increase or 6 times the increase or a flat out upfront fee for a template for $300 or whatever kind of baloney product people are selling. Just blows my mind. So I'm just going to say veterans, right? Veterans can still submit VA claims on their own or use other accredited consultants. Now, this part is really going to be controversial here, and I want everyone to pay attention to this part right here. So let's go ahead and look very, very close. Rudman and Soto's subjective beliefs, not objective, subjective, and we see this in the comments all over the channel all the time, that all other accredited agents or attorneys will be unable to provide effective assistance, and that Veterans Guardian will provide the best and possibly only opportunity to achieve a successful result. This is speculative and is not the kind of showing necessary for the extraordinary remedy of a preliminary injunction. So basically, they're saying they're denied again. The court does not find the law to be overboard, so the New Jersey law stands firm, baby. New Jersey, you did it. First of your kind. Crazy how New Jersey is the first of its kind. But hey, good on you. As plaintiffs have failed, probably my favorite sentence in here, to show a likelihood of success on the merits of their claims, they are not entitled to a prelim injunct relief, and their motion seeking a prelim is therefore denied. For the foregoing reasons, plaintiff's motion for prelim injunction is denied. An appropriate order will follow this memorandum opinion. Signed, this judge, United States District Judge. That is absolutely huge news for one, companies in general, and two, I would argue that it is a win for veterans. Now, obviously, if you're on the side of you drink the Kool-Aid from these companies, which is completely okay, that's going to be a big loss, right? So, I hope that I hope everyone sleeps good tonight. I know I will. And that's all I got.